You've just signed an offer, and now you're being told you need to send $50,000 as a deposit. Now, for most buyers, this is the moment where things start to feel very real. My name is Zachary Soccio-Marandola. I'm a real estate lawyer here in Toronto, and I help people like you close real estate deals every single day. Now, in this video, I'm going to answer 6 of the most common questions I get about real estate deposits, and I'm going to share a few practical tips to help you protect yourself along the way. So, question number 1, what exactly is the deposit? Here's how I like to describe it. A deposit is money that the buyer puts up as security for the deal. It's meant to show that the buyer is serious about completing the transaction. Now, if the deal closes, your deposit gets credited towards the purchase price. But if the deal doesn't close, this can be lost. More on that later. At its core, the deposit is there to give the seller confidence that the buyer will actually close on the deal. And because of that, it plays a big role if something goes wrong later in the transaction. Question number 2, when do you actually have to pay the deposit? Now, the short answer is it depends on the agreement of purchase and sale. The contract dictates when the deposit is due. Now, here in Ontario, there are 3 common ways the deposit is delivered. The first is providing the deposit herewith, or literally with the offer. In this case, the buyer includes the deposit at the time the offer is submitted. This is a way of showing the seller that the buyer is serious and already has the funds available. The second option, and by far the most common, is deposit due upon acceptance. Under the standard Ontario Agreement of Purchase and Sale, upon acceptance has a defined meaning. It means 24 hours from when the offer was accepted. That's why the exact timing of acceptance matters, because the 24-hour clock starts running from there. The third option is as otherwise described in this agreement. Now, this is where the parties can agree to custom deposit terms. For example, you might draft a clause that says the deposit is due within 3 business days, maybe because the buyer is traveling. Or you can write a clause that says the deposit will be delivered in multiple installments with different deadlines. In those cases, page 1 of the agreement will show as otherwise described, and then those specific deposit terms will be set out later in Schedule A. Now, the most important thing to remember is that the deposit deadlines actually matter. They're not suggestions, and they're not flexible unless the agreement allows them to be. Missing a deposit deadline can end up being very costly. Question 3. Who holds the deposit? In most Ontario real estate transactions, the deposit is held by the listing brokerage in that brokerage's trust account. That's because brokerage trust accounts are highly governed. The money only gets released from there in 3 circumstances. Number 1, if the deal closes. 2, if the buyer and seller sign a mutual release directing what happens to the deposit. Or number 3, if there's a court order. Now, in some cases, usually in a private deal when there are no realtors involved, the deposit may instead be held by the seller's lawyer. But the key point is that the deposit is almost always held in a trust account. While these are the 2 most common options, there's actually no rule that says the deposit has to be held in one specific place. The deposit can technically be held wherever the buyer and seller agree. That said, there are very few situations where holding the deposit outside of a brokerage or a lawyer's trust account is actually a good idea. Question number 4, is the deposit refundable? The answer is sometimes, if the contract allows it. So a deposit is refundable when the agreement of purchase and sale gives the buyer a legal right to walk away from the deal. The most common example is during a conditional period, where a condition like financing, inspection, or status certificate is not fulfilled and the deal is terminated. In those situations, the condition clause is typically written so that if the condition is not fulfilled, the deposit is returned to the buyer in full without deduction. Now, what's important to understand is that the deposit is not refundable just because something went wrong or because the buyer no longer wants to proceed. If the buyer does not have a contractual right to terminate the agreement, the deposit does not automatically come back. At that point, it becomes in dispute. This is why wording of conditions and how and when they can be exercised matters so much. The refundability of the deposit is entirely driven by what the contract says or what the parties agree to later on. Question number 5, what happens if you don't pay the deposit? There's a common misconception that not paying the deposit is somehow a way out of the agreement. That's not true. Once the agreement of purchase and sale is accepted, the deposit is not optional. The buyer is legally required to deliver it in accordance with the contract. So if the deposit isn't paid when it's due, that's a breach of contract. And in that situation, the seller can pursue damages, which will often include the amount of the deposit and can also include any shortfall that they sell the property to someone else for less money. If the deposit isn't paid when it's due, that's a breach of contract. And in that situation, the seller can pursue damages, which will often include the amount of the deposit itself, and can also include any shortfall if they sell the property to someone else for less money. That's why deposit timing is taken so seriously. Missing a deposit deadline could put a buyer at risk and ultimately be a costly mistake. Question 6. Do you get your deposit back if you don't close? In most cases, no. If a buyer fails to close a firm deal, the deposit is often forfeited to the seller. There's plenty of case law in Ontario that supports this. The deposit is generally treated as security for the buyer's promise to complete the transaction, and when that promise isn't kept, the seller is typically entitled to keep it. What surprises a lot of people is that the seller may still be entitled to keep the deposit even if they resell the property and even if they don't end up losing money on the resale. It's also important to understand that the deposit is separate from any additional damages. The seller may keep the deposit and still pursue further losses if the circumstances justify it. This is why deposits carry real weight. Once the deal is firm, the deposit is no longer just money sitting in trust. It's money that's genuinely at risk if the buyer doesn't close. The only way that money comes back to the buyer when the deal doesn't close is if the buyer and seller sign a mutual release. This is typically done when the circumstances lead to both parties just wanting to walk away, and that generally happens when there's no direct fault. The way I usually describe real estate deposits, they're simple when everything goes right, but very difficult when something goes wrong. Understanding how they work and when they're actually at risk can save you from some very expensive surprises. So if you found this video helpful, consider giving it a like and subscribing to our channel. I break down real estate topics like this every week from the legal side in plain English. If you have any other questions about deposits, drop them in the comments below and I'm happy to answer them. And if you're buying or selling real estate in Ontario and want the right kind of representation, my contact information is in the description below. Thanks for watching.